Nobody likes thinking about inheritance. It involves contemplating one's own mortality, which the British find particularly uncomfortable. We'd much rather talk about the weather. But here's the thing. If you're a British expat in France with assets in both countries and you haven't thought carefully about inheritance planning, the consequences for the people you leave behind could be significant, expensive and largely irreversible. The good news is that with the right planning, much of it is entirely manageable. The slightly less good news is that the rules have changed considerably in recent years in both countries. So let's work through it. Welcome back to the Expat Accountant. I'm Ad, a UK qualified accountant and British expat living in France. Today we're tackling inheritance, French succession law, French inheritance tax, and the significant changes to UK inheritance tax that came into effect in April 2025. There has also been a very significant development specifically affecting British expats in June 2026, just weeks before this video was filmed, that I want to make sure you know about. This is a topic where the interaction between two countries' legal systems creates genuine complexity and where the stakes are high enough that specific professional advice from both a French notaire and a cross-border advisor is essential. As always, this is general information, not personal advice. Right, let's go. Let's start with French succession law, specifically the concept that surprises almost every British person who encounters it for the first time. In the UK, you have what lawyers call testamentary freedom. You can leave your estate to whoever you like, your children, your spouse, your cat, or a particularly deserving donkey sanctuary. It's your choice. France takes a rather different view. French succession law includes a system called réserve héréditaire, forced heirship. This is a Napoleonic concept that has been on the statute books for over 200 years and shows no sign of leaving. It provides a fixed portion of your estate must pass to your children, regardless of what your will says. You cannot disinherit your children under French law. France considers this a matter of family solidarity and social stability. Your children may consider it very thoughtful of France. The reserved portions work as follows. If you have one child, they are entitled to at least 50% of your estate. Two children, they share at least 2/3 between them. 3 or more children, they share at least 3/4. The remainder, called the quotité disponible, is yours to leave as you wish. For many British couples, the immediate concern is what happens to my spouse. Under French succession law, if you have children, your spouse does not automatically inherit everything. Your children have prior claims on their reserved portions. Your spouse's rights depend on several factors, including whether you have children together or from previous relationships. The situation with blended families and stepchildren is particularly complex under French law. Stepchildren are not treated as children unless legally adopted, which creates situations that can be genuinely distressing for families who haven't planned ahead. Now, here's where it used to be complicated for British expats and where there has been a very significant and very recent development that I want to make sure you know about. Since August 2015, an EU regulation known as Brussels 4, officially the EU Succession Regulation 650/2012, Brussels 4 simply being the fourth in a series of EU cross-border legal regulations, has allowed individuals to elect the law of their nationality to govern their succession rather than the law of the country where they live. For British expats in France, this meant you could elect English or Scots law to apply to your estate, bypassing the French forced heirship rules and leaving your assets to your spouse entirely if you wished. Brexit did not remove this option. Brussels 4 is now part of French domestic law rather than purely EU law, and France has continued to apply it to British nationals. You can still elect UK law in your will. In November 2021, France introduced a controversial amendment, Article 913 of the French Civil Code, which threatened to undermine that election. It introduced what's called a compensatory levy, allowing children to claim their French reserve portion from French assets even where UK law had been elected. This caused significant concern and legal uncertainty for British expats across France for several years. However, and this is genuinely good news and genuinely recent news, in October 2025, the French authorities officially confirmed to the European Commission that Article 913's compensatory levy does not apply where English law governs the succession. France has recognised that English family provision law, the legal mechanism allowing a disinherited child to make a claim in an English court, is a functional equivalent of the French hereditary reserve. Because English law already has its own child protection mechanism of a different kind, France has accepted that its compensatory levy is not triggered. The European Commission published a pre-closure letter in June 26, just weeks before this video was filmed, confirming this position and indicating it intends to close its investigation. For British expats electing English law in their French will, the Article 913 threat has been substantially resolved. There are two important caveats. First, if you are Scottish, the position is less clear. Scots law works differently from English law, and you should take specific legal advice on whether it qualifies in the same way. Second, this clarification does not affect French inheritance tax. Electing English law changes who inherits your estate. It does not change what French inheritance tax applies to French situated assets. The tax position remains governed by French law regardless of your succession law election. The practical upshot, electing English law in your French will is once again a reliable and effective planning tool for most British expats in France. But it should be done properly with a specifically drafted French will prepared by a notaire or cross-border legal specialist. A UK will alone is not sufficient. Right, let's talk about French inheritance tax, the droit de succession. This is separate from succession law. It's about how much tax is paid on what is inherited, regardless of who inherits it. The good news first, and there is some. Spouses and pact civil partners are completely exempt from French inheritance tax. Whatever they inherit, they pay nothing. This is considerably more generous than the UK system, where the nil rate band and resident nil rate band apply, but there is still a framework of thresholds. France simply exempts spouses entirely. On this point at least, France gets full marks. Children receive a tax-free allowance of 100,000 each per parent, so each child can inherit up to 100,000 euros from each parent before tax applies. Above that threshold, French inheritance tax rates start at 5% and rise progressively to 45% on amounts above approximately 1.8 million euros. For most families, these rates are manageable. It's the allowances that matter most. Beyond children and spouses, the picture is considerably less generous. Siblings face tax rates of 35% to 45%, with a tax-free allowance of just 15,932 euros. Nephews and nieces face 55% above 7,967 euros. And for the unrelated beneficiaries, including unmarried partners not in a pact, the rate is 60% above a mere 1,594 euros. If you have a long-term partner and you are not married or in a pact, French inheritance tax could take 60% of what you leave them above that tiny allowance. It is one of the strongest arguments for formalising your relationship legally in France that I can offer. And I'm an accountant, not a romantic. Now let's talk about a very significant change on the UK side that came into effect on the 6th of April 2025 and that every British expat in France needs to understand. Prior to April 2025, UK inheritance tax was based on the concept of domicile. If you were UK domiciled, essentially if the UK was your permanent home in a legal sense, HMRC taxed your worldwide assets. If you had established a non-UK domicile, for example by making France your permanent home, only your UK assets were within the scope of UK inheritance tax. From the 6th of April 2025, domicile has been abolished as the test for UK inheritance tax. The new test is based on residence. Specifically, if you have been UK tax resident for at least 10 years of the previous 20 tax years, you are classed as being a long-term UK resident, and your worldwide assets are within the scope of UK inheritance tax wherever you live. What does this mean for British expats in France? If you spent significant years working in the UK before moving to France, and most British expats did, you may well meet the 10 out of the 20-year test for some years after your move. During that period, HMRC considers your worldwide assets, including your French property and French investments, potentially subject to UK inheritance tax at 40% above the nil rate band. There is also a tail provision. Even after you cease to meet the long-term resident test, your worldwide assets remain within UK inheritance tax scope for a further period, anywhere from 3 to 10 years, depending on how long you were resident. Simply leaving the UK does not immediately remove you from the scope of UK inheritance tax on worldwide assets. France introduced a similar concept decades ago. HMRC has now followed suit. The UK-France Double Tax Treaty on Inheritance, which dates from 1963, does provide relief to prevent the same assets being fully taxed twice, but navigating the interaction between French droit de succession and UK inheritance tax on the same estate requires careful planning. This is emphatically not a DIY situation. Right, given all of that, what can you actually do about it? Here are the main planning tools available to British expats in France. Make a will in both countries. A French will and a UK will working in conjunction with a Brussels 4 election in the French will if appropriate for your circumstances. Many people have one or the other, but not both. You need both. And given the June 2026 clarification, electing English law in your French will is once again a reliable and effective planning tool. Make sure yours is up to date and properly drafted. Consider your pax or marriage position. If you have a long-term partner in France and you are not married or in a pax, the French inheritance tax exposure is severe. Formalising your relationship is one of the most effective inheritance planning steps available. The tontine clause. When purchasing French property as a couple, it is possible to include a tontine clause in the purchase deed. This means the surviving partner automatically becomes the sole owner of the property on first death, outside the normal succession rules. It's not suitable for everyone and has its own tax implications, but for some couples it is a very effective planning tool. The Assurance V. As I mentioned in the ISA video, the Assurance V is extremely efficient for inheritance planning in France. Assets held within an Assurance V policy pass outside the normal succession rules and with favourable tax treatment. up to €152,500 per beneficiary, tax-free for policies funded before age 70. It's one of the most powerful planning tools available to French residents and one I'll cover in its own dedicated video. Lifetime gifts. Both France and the UK allow gifts during your lifetime to reduce your eventual inheritance tax exposure. In France, you can give up to €100,000 per child every 15 years, free of gift tax. Planning gifts strategically and keeping records carefully is worth discussing with an advisor. So, to summarise, French succession law imposes forced heirship. Your children have legal rights to portions of your estate regardless of your will. You can elect English law under Brussels 4, and following the important June 2026 clarification, Articles 913's compensatory level should not apply to English law wills. This is genuinely good news. Scottish residents should take specific advice as the position for Scots law is less clear. French inheritance tax is generous for spouses and reasonable for children, but punishing for anyone further removed, including unmarried partners. From April 2025, UK inheritance tax has moved to a residence-based system, meaning many British expats remain within its scope on worldwide assets for years after leaving the UK, with a tail of between 3 and 10 years, depending on how long you lived there. And the interaction between French and UK inheritance tax requires careful cross-border planning. This is a topic where doing nothing is genuinely expensive. A will review, a conversation with a notaire, and advice from a cross-border financial advisor are not optional extras. They are the foundation of sensible estate planning as a British expat in France. And with the rules having changed significantly in both countries in the past year, if you have not reviewed your position recently, now is the time. Next week, I'm covering the Assurance V in detail, what it is, how it works, and why it's one of the most powerful financial planning tools available to British expats in France. Subscribe so you don't miss it, leave your questions below, and I will see you next Wednesday.